Good morning, bar people. How's everyone doing? All right, let's cram all of legal knowledge into my head. All right, let's do this thing. Let's see. Thank you, Michael, for being a member. It's appreciated. Okay. A statute passed by both houses of Congress and signed by the President authorizes a federal agency to select a site for and construct a monument honoring members of the Capitol Police Force killed in the line of duty. The statute appropriates necessary funds, but provides the funds may not be expended until both houses of Congress have adopted a concurrent resolution, not subject to presentment to the President, approving the agency plans for building the monument location design. That sounds... Is the provision requiring further congressional approval before expenditure of funds constitutional? No, because the decision regarding placement design of government-owned structures are an exclusively executive function with which Congress may not interfere by any means. That's definitely wrong. No, because the provision amounts to unconstitutional legislative interference in executive function. Possible. Yes, because Congress may attach reasonable conditions to its appropriation of funds to executive departments, and its special interest in members of its own police force makes the provision a reasonable condition. Possible. Yes, because the provision is part of a statute that's passed by both houses of Congress and signed by the President. That's the wrong answer. So it's either B or C. I'm going to say it's C. It's B. Yeah, that's fine. A boater was rowing a boat on Mountain Lake when a storm suddenly arose. Fearful the boat might sink, the boater rowed to a boat dock on the shore and tied the boat to the dock. The shore property and dock were on private property. While the boat was tied at the dock dock owner came down, or the boater removed the dock because the action of waves was causing the boat to row against the bumper of the dock. When the boater refused, the owner untied the boat and cast it adrift. The boat sank. The boater was wearing a pair of swimming trunks, nothing else. He had a pair of shoes and parked in the boat, but they were lost when the owner set it adrift. The boater was staying at a cabin 1 mile from the owner's property. The only land routes back were by a short, rocky trail that was dangerous during the storm, and a 15-mile road around the lake. The storm continued with heavy rain and hail, and the boater, having informed the owner of the location of the cabin, asked the owner to take him back there in the owner's car. The owner said, "You got here by yourself, and you have to take yourself back home." After 1 hour, the storm stopped, and the boater walked across the trail. If the boater asserts a claim against the owner for loss of boat, the most likely result is the owner is going to lose. Have no defense under these circumstances. Prevail because the boater was a trespasser from the beginning. Private necessity. It was privileged entry. Prevail because the boater might have damaged the dock. No. Prevail because the boater became a trespasser when he refused to move the boat. He didn't have to. Privileged entry. No defense under these circumstances. Yeah. Next answer. A man sent an email to a friend that stated, "Because you've been a great friend to me, I'm going to give you a rare book I own." A friend replied by email that said, "Thanks for the rare book. I'm going to give you my butterfly collection." These are mutually exchanged gifts, which is not a contract to make. The rare book was worth $10,000. The butterfly collection was worth $100. It's still not a contract. The friend delivered the butterfly collection to the man, but the man refused to deliver the book. Well, that's unfortunate, but it's not a contract. If the man chooses to recover the value for the book, how should the court rule? Sucks to be you. For the man, because there's no bargain for exchange, there you go, there's no contract. For the man, because consideration was given for his promise was inaccurate, it's not a promise. For the friend, because they gave butterfly collection to the man in reliance on receiving the book, no reliance. For the friend, because she conveyed a benefit to the man by delivering the butterfly collection. No, it was a pure gift. There's no bargain for exchange, and that's the right answer. A woman was standing in the aisle of a subway car and put her purse on the seat next to her. A man approached the woman from behind and grabbed the purse off the seat. He then pushed the woman out of the way and ran out of the subway car while carrying the purse. The man was apprehended in the subway platform. In a jurisdiction follows common law with respect to criminal offenses. What can the man be charged? Well, larceny, battery, sounds good. The purse is on the seat next to her, so not robbery because it's not on her person or attached to her. She had been carrying the purse, robbery, but it's on the seat next to her, so no robbery. Well, yeah, he grabbed the purse and pushed the woman out of the way. It's not robbery. That's what they're trying to test me for. Anyways, larceny because force was not used until after he took the purse, promising. Larceny because he made no threat of use of force. Okay. Robbery because he physically took the purse from the woman's presence. It's not under the common law. Robbery because he used force in leaving with the purse. No, I think the force has to be used in the taking, not in like the aftermath. Is it A or is it B? Larceny because he made no threat of use of force. Larceny because force was not used until after he took the purse. I'm not sure. I want to say A, but I'm not sure. It's D. The man met the elements of larceny by running away with the purse with the intent to retain. Additionally, the purse was taken from the seat next to the woman within her presence and pushed her away. Therefore, the man may be convicted of robbery. And timing when using force is not part of the analysis, really. Robbery is the wrongful taking of another person from his property or presence. Really? It only has to be in a person's presence? I thought it had to be from his person. Okay. Through force or use of injury with intent to deprive. So in your presence is sufficient for it to be a robbery? Okay. Well, you learn something new every day. A defendant is charged with robbing a bank. The prosecutor supplied the court with information from accurate sources establishing the bank is a federally insured institution, and this fact is not subject to reasonable dispute. The prosecutor asks the court to take judicial notice. The defendant objects. How should the court proceed? Well, they should take judicial notice, and they should instruct the jury that they can find it as a fact if they want, but not that they must because it's a criminal case. The court must take judicial notice. They don't have to. The court must take judicial notice. They don't have to. The court may refuse to take judicial notice because judicial notice may not be taken of essential facts in a criminal case. I'm not sure it's an essential fact, but okay. The court must refuse to take judicial notice because where the fact is federally insured will not be generally known within the court's jurisdiction. Let's give it another try. The court must take judicial notice. I didn't think judicial notice is required, but I guess it must be. The court must take judicial notice and instruct the jury that it's required to accept it. No. The court must take judicial notice and instruct it may, but not be required to. I guess B, I just didn't know the court was required to. Apparently it is mandatory. Okay. A defendant was convicted of fraud after a jury trial in state court. The conviction was affirmed on direct appeal. The defendant timely moved on post-conviction relief under the Sixth Amendment on the ground that his attorney had provided ineffective assistance to counsel. The trial judge, after a hearing, found the attorney had performed deficiently by failing to raise proper objection that would have resulted in exclusion of important prosecution evidence. What more, if anything, must a trial court find in order to sustain defendant's Sixth Amendment claim? Nothing more, because unjustifiable failure to object to important prosecutorial evidence is structural error. That the attorney was court-appointed and not privately retained, that's meaningless. There's a reasonable probability the trial outcome would have been different if the attorney had objected. There is clear and convincing evidence the trial would have been different had objected. I think the reasonable probability is the correct standard. Yeah. A victim injured by a driver in an auto accident employed an attorney to represent him in the matter. The victim was chronically insolvent and expressed doubts whether he could promptly get necessary medical treatment. Accordingly, the attorney wrote in their contract his promise to the victim to pay for any settlement with the driver compensation any physician who provides professional services to the victim's injury. The contract also provided the attorney's duties were non-assignable. The attorney immediately filed suit against the driver. I'm confused. The victim sought and received medical treatment reasonably valued at $1,000 from the doctor, but failed to inform the doctor of the attorney's promise. After receiving a bill for $1,000, the victim immediately wrote the doctor explaining that he was unable to pay and enclosing a copy of his contract with the attorney. The victim asked the attorney about the payment of the bill, but the attorney requested a release from their employment contract, stating that he would like to refer the victim's claim to a colleague, and the colleague was willing to represent the victim in the pending lawsuit. The victim wrote a letter to the attorney releasing him from the contract and agreeing to the colleague's representation. A copy of this letter was sent to the doctor. The colleague subsequently promised the attorney to represent the victim and soon negotiated a settlement of the victim's claim against the doctor, where he netted $1,000, all of which was paid to the victim's creditors other than the doctor. The victim remains insolvent. Inaction by a doctor against the attorney upon the attorney's employment contract with the victim. The attorney is most likely to argue in his defense. The anti-assignment clause in the attorney's contract with the victim is void against public policy? No. The attorney had relied to his detriment on victim's release, promising. Third parties cannot acquire valid claims under an attorney-client contract. I don't see why not. The doctor's materially changed his position upon reliance of the attorney's employment contract. Well, it's either B or D. D. Is it B? Oh, it's D. Okay. The issues were okay. A buyer purchased 100 bolts of standing of blue wool, number 1 quality, from a seller. The sales contract provided the buyer would make prior payment prior to inspection. 100 bolts were shipped, and the buyer paid the seller. Upon inspection, however, the buyer discovered the wool was number 2 quality. The buyer thereupon tendered back the wool to the seller and demanded a return. The seller refused to take back the wool or return payment on the ground there's no difference between number 1 quality and number 2 quality. Can the buyer resell the wool? Yes. Yes, in a private sale. Yes, in a private sale, but only if given reasonable notice of intention to resell. Yes, but only in a public sale? No. This is dealing with he has to do it in some sort of commercially reasonable way. I don't think he has to give notice. Does he have to give notice or not? Under the UCC. I'm going to say B. It is B. A gas company owns a storage facility where flammable gases are stored in liquefied form under high pressure in large spherical tanks. This facility was designed by the gas company and constructed for the gas company by a construction company that specialized in construction of such facilities. After the facility had been used for 5 years, an explosion in the facility started a large fire that blanketed the surrounding countryside with a high concentration of oily smoke and soot. The explosion was caused by an obvious defect in design of the storage facility. A farmer owns a lettuce farm near the facility. His entire lettuce crop was destroyed by oil deposit left by the smoke. A neighbor who lives near the facility inhaled a large amount of smoke, and thereafter became obsessed by the fear that an inhalation would destroy his health and ultimately cause his death. If the farmer asserts a claim against the construction company for loss of his lettuce crop, will he prevail? Yes. No, because the construction company did not design the forage facility. It doesn't matter. No, because the construction company was an independent contractor. It doesn't matter. Yes, because the operation of the storage facility was abnormally dangerous. Promising. Yes, because the exclusion resulted from a defect, of which the company should have been aware. No, the issue is that it's abnormally dangerous. I'm pretty sure. No? Only built the facility and was not responsible for the storage of the gas. Under the facts, the gas company was the owner-occupier, making the gas company responsible for storage of the flames. Totally makes sense. Yeah, the abnormally dangerous activity is the storage of the stuff, not the building of the thing. So, yeah, that makes logical sense. I get it. A pedestrian died from injuries caused when a driver's car struck him. The pedestrian's executor sued the driver for wrongful death. At trial, the executor called the nurse to testify that 2 days after the accident, the pedestrian said to the nurse, "The car that hit me ran the red light. 15 minutes thereafter, the pedestrian died." As foundation for introducing evidence of the pedestrian statement, the executor offers to the court the doctor's affidavit. The doctor was the intern on duty the day of the pediatrician's death, and several times that day, the pedestrian said he knew he was going to die. So it's a dying declaration, okay, which can be offered in a civil case or a murder case, I think. Yeah. Is the affidavit properly considered by the court in the ruling on this statement? Yes, because we need to determine if it's a dying declaration. Sure. No, because it's hearsay not within any exception. No, it's irrelevant since dying declarations can only be used for prosecutions for homicide. No, they can be used in civil cases too. Yes, because though hearsay, it's a statement of then existing mental condition. Promising. Yes, because the judge may consider hearsay in ruling on preliminary questions. Well, that too. The answer is D. Yeah. So we don't even need a hearsay exception at all. Although there is one, we don't need it. Because we're on a preliminary question and the judge can consider hearsay. The rules of evidence, man. The rules of evidence. Hearsay is acceptable these times, but not these times. And this way, but not this way. And this thing and not this thing. It's like, yeah, fun times. Anyways, carrying on. A seller and a buyer signed a contract for sale of vacant land. The contract was silent concerning the quality of title, but the seller agreed in the contract to convey the land to the buyer by a warranty deed without any exceptions. Okay. When the buyer conducted title search for the land, she learned the applicable zoning law did not allow for her planned commercial use. She also discovered there was a recorded restricted covenant limiting the use of the land to residential use. The buyer no longer wants to purchase the land. Must they purchase the land? Well, let's see. No, because the restricted covenant renders the title unmarketable. Promising. No, because zoning places cloud over the title. No, it doesn't. Yes, because the buyer would receive a warranty deed without any exceptions. Yes, because the contract was regarding. The restricted covenant renders the title unmarketable. I'm pretty sure is the answer. It is the answer. Next question. Thank you very much, Arlene. I appreciate it. A buyer purchased a house for $300,000. The buyer financed the purchase in part with $250,000 loan from a bank secured by mortgage on the house. Before the closing, the buyer's attorney advised him to purchase a standard form $300,000 title insurance policy, naming the buyer as the insured. Because the buyer had forgotten to bring his checkbooks to the closing, the son, who accompanied the closing, paid the premium. Well, that's fine. Someone paid it. 1 year later, the buyer died. Under his will, the house passed to his son. 2 years later, the son was successfully sued by a previous record owner with a superior title to the house. The previous owner's claim had not been accepted by the buyer's title policy through the carelessness of the title company. Well, they're going to have to pay out them. At the time of the lawsuit, the house was still subject to the bank's mortgage. Son immediately sought indemnification for the loss from the title insurance company. Is son entitled to indemnification? Hell yes. No, because the son was not named as insured on the title policy. It doesn't matter. No, because when a mortgage remains outstanding, a title policy protects only the mortgagee from loss. No, it doesn't. Yes, because the house passed his son under the buyer's will. That's the correct answer. Yes, because the son paid the policy premium. It's irrelevant. The answer is because the house passed to him, and so he inherits the insurance, as it were. Next question. A famous chef entered into a written agreement with his neighbor, a well-known interior decorator, respected for his unique designs, in which the decorator agreed for a fixed fee, design the interior of the chef's new restaurant, and upon the chef's approval, design plan to decorate and furnish the restaurant accordingly. The agreement was silent as to assignment or delegation. Before beginning the work, the decorator sold his decorating business to his friend, under agreement in which the decorator signed to his friend, and the friend agreed to complete the irrelevant contract. Fine. The friend, also an experienced contractor of excellent repute, advised the chef of the assignment and supplied him with information concerning both the friend's financial responsibility and past commercial success. If the chef allows the friend to perform and approves his design plan, but the friend fails without legal excuse to complete the decorating, against whom does the chef have an enforceable breach of contract? Against them both. The decorator only, because the decorator's agreement with the friend did not discharge his duty to the chef, and friend made no express promise. Only the friend, because the decorator's duty to the chef was discharged when the decorator obtained a skilled decorator. Only the friend, because the chef was intended beneficiary. Either director, because of his agreement with the friend, did not discharge his duty, or the friend, because he was intended beneficiary. I'm pretty sure either one will be fine. And then either one will be fine. Great. Next. Is the exam today? The exam is a week from tomorrow. If the exam was this morning and I was still doing practice questions, A plaintiff sued defendant for unlawfully using plaintiff's idea for Animal Robot as a character in defendant's science fiction movie. For the idea of it, you're going to have a problem, right? But let's press on. Defendant admitted he had received a model of an animal robot from the plaintiff, but denied he had any substantial similarity to the movie character. After the model had been returned to the plaintiff destroyed it. In order for the plaintiff to testify about the appearance of the model, the plaintiff must show he did not destroy the model in bad faith. That would help. Must give advance notice of intent to introduce oral testimony. No. Must introduce a photograph of the model if one exists. Probably. Need not do any of the above because the best evidence rule applies only to writings, records, and photographs. He must show he didn't destroy the model in bad faith. No? Okay, so the best evidence rule doesn't apply because it is not a writing, recording, or photograph. So the best evidence rule does not apply because it's not a writing, recording, or photograph. Okay. The general manager and chief executive officer of a knitting mill delegated all operational decision-making to the supervising manager of the mill. The child labor laws in the jurisdiction provide it is a violation of the law for one to employ a person under the age of 17 years for full-time labor. Without the chief executive officer's knowledge, the supervising manager hired a number of 15 and 16-year-olds to work at the mill full-time. He did not ask about their ages, and they did not disclose them. The supervising manager could discover their ages by asking for identification, but he did not do so because he was not aware of the law and believed company's policy was to hire young people. If the statute is interpreted to create strict liability, and the supervising manager is charged with violating it, he is guilty because he should have inquired as to the age of children, guilty because he hired the children, that would be the right answer, not guilty because the knitting mill, not supervising manager, is the employer of the children, no, not guilty because he believes he is following company policy, not aware of the violation. Mistake of law? I don't think so. He hired the children, so he is the problem. Next one. The beneficiary of a decedent's life policy had sued the life insurance company for proceeds of the policy. At issue is the date when decedent first experienced heart problems that led to his death. Decedent's primary care physician testified at trial. The decedent had a routine checkup on February the 15th. The physician then identifies a photocopy of a questionnaire provided by the physician and completed by the decedent on that date, in which the decedent wrote, "Yesterday's afternoon, I broke into a big sweat and my chest hurt for a while." The beneficiary now offers the photocopy in evidence. Should the court admit the photocopy? Sure. Photocopy seems like it's going to be fine, I think. No, because the original questionnaire is not shown to be available. No, because the statement related to past rather than present symptoms. Yes, as a business record. Yes, as a statement for a purpose of obtaining medical treatment. D? Yeah. Thank you, Jerry. I'm feeling okay. A landowner owned and occupied Blackacre. Also, sub-count. A landowner owned and occupied Blackacre, which was a tract of land improved with a one-family house. His friend orally offered him $50,000 for Blackacre, the fair market value, and he accepted. Because they were friends, they saw no need for attorneys or written contracts and shook hands on the deal. The friend paid the landowner $5,000 down in cash and agreed to pay the balance of $4,500 at an agreed closing time and place. Before the closing, the friend inherited another home and asked the landowner to return $5,000. The landowner refused, and at the time set for closing, the landowner tendered a good deed to the friend and declared his intention to vacate Blackacre the next day. The landowner demanded the friend complete the purchase. The friend refused. The fair market value has remained $50,000. In an action brought by the landowner against the friend for specific performance, which in a real estate contract you can actually do that, as opposed to pretty much every other contract on the face of the earth, which good fucking luck. If the landowner loses, it will most likely be because, well, we have partial performance, which is going to excuse the statute of frauds. The agreement was oral. Keeping the $5,000 in exclusive remedy, the friend had a valid reason for not closing. The landowner remained in possession on the date set of closing. The $5,000 is the exclusive remedy. Well, the most likely reason that you're going to lose would be because the agreement says oral. Like, that is the most likely reason to lose. Because we're running right into a parole evidence, running right into a statute of frauds problem. Like, we have partial performance, which might excuse the statute of frauds, but the underlying problem is that we have an oral agreement relating to land, which is a statute of frauds problem. And so, yeah, that would be the most likely problem. I think it's a problem we can get past, but it's the most likely problem. Yeah, here's a pro tip for everyone out there. We're good friends. We don't need contracts. Yeah. Don't ever do that. Don't ever do that for everyone's sanity, please. Don't do that. It just leads to problems and hurt feelings and all the rest of it, right? You don't need contracts when everyone's happy. As long as everyone's happy, you don't need a contract. So if you're like, everyone's happy, therefore we don't need a contract, well, everyone better be happy forever. Everyone better be happy forever. We're friends. We don't need contract. Everyone's happy. We don't need a contract. Everyone better be happy forever. Because if anyone's ever not happy, well, yeah, don't do that. Just get the contract. It's for everyone's sanity. Pressing on. 10 months after surgery in a hospital, a patient who suffered complications from the surgery sued the surgeon and the hospital in federal court for medical malpractice, seeking $750,000. Your verbal contract is as good as the paper it's written on. Hey, that's not fair. Verbal contracts are perfectly valid in the vast majority of situations. There's only a few exclusions where verbal contracts are not valid under the statute of frauds. Shall we discuss? Let us discuss. Right? Under what circumstances does a contract need to be evidenced by writing? Well, if it's the sale of goods for more than $500, if it concerns land, if it is the assumption of debt of another, if it is in contemplation of marriage, what else? Oh yes, it cannot be completed within 1 year. Otherwise, oral contracts are perfectly fine. Merch link? What is merch link? You don't know what merch means? It just means merchandise. You can buy like stuff, like shirts and shit that you might want. Or so you could just click on it and find out. Anyways, the company moved to dismiss, arguing the forum state had enacted a 1-year statute of limitations for medical malpractice actions, and the company had been served after the limitations period had expired. The company also noted the state's highest court had interpreted the limitation statute as forbidding any relation back of amendments adding parties to medical malpractice actions. The patient argued the federal rules of civil procedure control and allow relation back under circumstances. Which law governs? This is substantive versus procedural, and I'm not doing very well in these questions. But let's try anyway. Federal law, because the federal rules of civil procedure govern over conflicting state rules that deny relation back. Federal law, because state law in relation back is common law, and federal courts are bound only by state statutory law. That's wrong. State law, because state statute of limitations are substantive, and state law controls substantive matters. Yeah. State law, because the federal rules of civil procedure authorize use of state law for relation back. C, because it's substantive. Oh, you've got to be kidding me. Federal rules of civil procedure prevail over conflicting state rules unless it can be found the federal rule at issue was promulgated in violation of the Rule Enabling Act. The Act authorizes the Supreme Court to prescribe federal procedural rules so long as they do not abridge, enlarge, or modify any substantive right. C is correct. Although state statute of limitations are outcome determinative and therefore controlling in federal diversity actions, the question posed here is whether the federal rules or state law controls the standards for deciding relation back to issues. See Guarantee Trust versus York of 1945. Thus, the fact that the statute of limitations statute applies to substantive claim does not answer the question whether the court should allow relation back to avoid consequence of missing the statute of limitations. Yeah. We have definitely identified Uncivil Law's most persistent weakness on the bar exam. Like, some of this stuff is just kind of obscure, or like I make mistakes or something, but the most continuing systemic mistake I continue to make is the difference between substantive and procedural rules when it comes to federal diversity actions. Okay, so I know that if I'm a federal court, I have to apply state substantive law, but I apply federal procedural law. So I know that. What I have trouble apparently determining is whether it's substantive or procedural. It's because just about every time I seem to get it wrong. So there's some weakness there. I guess it's good to know these things, though. I clicked it. It's merch link. It says Streamlabs, merch, then link. Yeah, exactly. Yeah. Now we know what to focus on. Yeah, no joke. Yeah, if I ever get nominated for the federal bench, note to self to study up a lot on substantive versus procedural. Although I'm probably sure I could bluff my way through it, to be honest, because, like, you know, these questions are hard and courts screw them up. So I don't know. But there's that merch link. All right, let's do some more. A corporation sued a defendant for 10 fuel oil deliveries not paid for. Defendant denied that deliveries were made. At trial, the corporation calls its office manager to testify that corporation's employees always record each delivery in duplicate, give one to the customer, and place the other copy in the corporation files. The office manager has the custody of these files, and his examination of the files before coming to court reveals that 10 deliveries were made. The office manager's testimony that the invoices are made is, well, can we get the actual records? That'd be nice. Admissible because it's based on regularly kept business records. Admissible because the office manager has first-hand knowledge of the contents of the records. Inadmissible because the records must be produced in order to prove their contents. Inadmissible because the records are self-serving. It's not exactly the contents that are in dispute, is it? It's like kind of that they exist at all. So I think A, admissible because they're kept on regularly kept business records. Is it C, because best evidence? That's fair. The testimony is admissible because it's being offered to prove the contents of the record. I totally understand this. This is fine. I agree. That's fine. You're going to buy a cup that says all the no? Cool. I made a variety of different cups. I hope they come in different colors. I hope one of them will be to your liking. I am glad that you like the cup in orange. I hope you enjoy it and it brings you much happiness. An investor has sued a broker in federal court, and if you buy it, hypothetically, it should pop up on screen. So we'll find out whether or not you really bought it or not. Because if you did buy it, it should pop up on screen saying that you bought it. Let's find out. Okay. An investor has sued a broker in federal court for violation of federal security law, claiming the broker misrepresented the investments he made on the investor's behalf. The investor and the broker are citizens of State A. The broker would like to assert a breach of contract claim as counterclaim to the investor's action, alleging the investor has failed to pay the broker for investments made on their behalf. Can the broker join the contract claim? Oh, sure. Why not? Well, no, not necessarily, because it's not of the same facts, same matter. It's the same parties, though, but it's not deriving out of the same situation. I don't know. I mean, maybe. Let's look at the answers. Can they join the claim? No, because the contract claim is governed by state law. That's the wrong answer. No, because the parties are not diverse. That's not the problem. We have a federal question. We can get their supplemental jurisdiction. Yes, because the contrary claim is compulsory. No, it's not. Yes, because it's permissible. Permissible sounds right. I don't think it's compulsory. Is it compulsory? It arises out of the same transaction or occurrence? Okay. Yeah, so is it compulsory or not? I was like, I don't think so. I mean, it arises out of the same transaction or occurrence. Okay, fair. A buyer agreed to purchase a seller's house for $250,000 on condition the buyer obtain a mortgage financing within 30 days. 30 days later, the buyer told the seller the buyer would not purchase the house because the buyer had not obtained the mortgage financing. He's obligated to try. If he couldn't do it, fine, but he's obligated to try. He can't just not do it. The seller asked the buyer where the buyer had tried to obtain the mortgage financing, and the buyer responded, I was busy and I didn't have time. If the seller sues the buyer for breach of contract, is the court likely to find the buyer in breach? Yep. No, because the buyer performance was subject on a condition that didn't occur, but he's the one that caused it not to occur, so no. No, because the promise was a loser since the buyer was not obligated to do anything. Yes, he was. Yes, because the promise was implied, the buyer had to make reasonable efforts to obtain mortgage financing. There you go. Yes, because a reasonable interpretation agreement, the buyer had an obligation to purchase it. No, he had to make reasonable efforts to obtain. If he had made reasonable efforts to obtain and failed, he'd be fine, but he didn't. So, yeah, no. And a promise is implied. Good faith and fair dealing, my friends. Good faith and fair dealing. It is implied in every contract. You have to try. An investor purchased a tract of commercial land, financing a large part of the purchase price with a loan from a business partner that was secured by a mortgage. The investor made the installment payments on the mortgage regularly for several years. Then the investor persuaded a neighbor to buy the land subject to the mortgage from his partner. They expressly agreed the neighbor would not assume and agree to pay the investor's debt to the partner. Okay. The investor's mortgage to the partner contained a due on sale clause stating, if mortgagor transfers his or her interest without written consent to the mortgagee first, mortgagee's option of the entire principal balance on debt secured by the mortgage shall become immediately due and payable. Yes, the loan is no longer secured, so they want the entire loan. This is pretty standard. Sure. However, without seeking his partner's consent, the investor conveyed the land to the neighbor, the deed saying it was subject to the mortgage by the partner. Fine. And giving details and recording the day relating to the mortgage. The neighbor took possession of the land and made several mortgage payments on it, which they accepted. Okay. So now we have an arguable consent issue, because now we're accepting payments on it. Now, however, neither the neighbor nor the investors made the last 3 mortgage payments. The partner sued the neighbor for the amount of the delinquent payments. In for this action, for whom should they join? Oh, either one will be fine. Either one should be fine. The neighbor, because she did not assume and agree to pay the investor's debt. The neighbor, because she's not in privity of the estate with the partner. The partner, because the investor's deed to the neighbor violated the duty on sale clause. The partner, because neighbor is in privity of the estate with the partner. I'm going to say D. We're in privity of estate. A. The explicit agreement of the neighbor would not assume the liability, insulate the neighbor from liability, even though she did make several payments voluntarily. That makes fair. Yeah, the Uvalde stuff I took down. I took it down because, like, I don't know. It was me ranting and raving and, like, just, like, I don't know. I thought maybe I'd make something else about it. Maybe I'll make it public again. Maybe I'll make another ranting video. I don't know. But the whole thing is pissing me off. So, yeah, I took it down because I was like, I don't know what to do with this. So, yeah. Hey, there you go. There's the cat. There we go. The work. Help your cat drive. Bought all the know. Thanks for a great channel. Really appreciate it. Hey, and it even pops up a little icon of the thing you bought. Cool. Excellent. Thank you for your purchase. That's very cool. That's one of the reasons, incidentally, I used the. It's one of the reasons, incidentally, I used the Stream Labs thing, because it's all integrated, and so we get those cool little pop-ups. I guess I could do the cool little pop-ups like through a third party if I set up something, but like the fact that it was built in was kind of nice. So I hope you enjoy your mug. Thank you for your purchase. You might be the first person who's actually purchased a piece of merch, so congratulations to you for your merch purchase. You are the first merch purchase. You are a cool person. Yeah. A rectangular parcel of undeveloped land contained 3 acres and 150 feet of frontage of public street. The applicable zoning ordinance required that a buildable lot contain at least 2 acres and a frontage of not less than 100 feet on the public street. A brother and sister owner of the land as tenants in common. The brother owning a 1/3 interest and the sister owning a 2/3 interest. Neither of them owned any other real property. The sister brought an appropriate action to partition the land as tenants in common. I think you can do that. Yeah. The sister brought an appropriate action to partition the land and proposed the 2-acre rectangular lot with 100 foot of frontage be set off to her, and a 1-acre rectangular lot with 50 feet of frontage be set off to the brother. The brother's defense included a demand the land be sold, and its proceeds be divided 1/3 and 2/3. Who will prevail? The brother, I guess. Because not for at least the reasons like the proposal violates the zoning ordinance. So it has to be sold and retail split sounds better. The merch link isn't in the description. The merch link pops up from time to time. I probably should put the merch link in the description. That would probably be a logical thing to do. Let me do that. Let me answer this question first, and then let me do that. The brother, because partition by sale is a preferred remedy, unless a fair price is not likely to result. The brother, because the zoning ordinance makes it impossible to divide the land fairly. Sounds, yeah. The sister, because partition by sale is not appropriate if the subject property can be physically divided. The sister, because the ratio of the two lots that result from a proposal conforms exactly to the ownership ratio. I think the issue is here the zoning regulation. If memory serves correctly, and it's been literally 15 years, but I believe division is preferred over sale. So the issue is that the zoning ordinance makes that impossible. So, B? Something you haven't read for 15 years, you know? Are these sessions available as a replay? No, these sessions are not available as replay. Not the bar prep sessions, no. They're not good for the channel. In terms of the channel, they're not good for the channel in terms of growth and the analytics and retention rates and all the rest of it. They drag the channel down. So keeping them up is not good for the channel. Strictly speaking, streaming them is probably not good for the channel, but my own bar prep comes first, and I find streaming them to be a productive exercise. So yeah, we're doing that now. Alright, merchandise is now in the video description. I'm using a private bar prep program for bar prep. Congress enacted a statute directing U.S. ambassadors to send formal letters to the governments of their host countries protesting any violations by those governments of international treaties on weapons sales. The president prefers to handle the violations by certain countries in a less formal manner, as in directed ambassadors not to comply with the statute. Is the president's actions constitutional? Almost certainly yes, because this is within the province of the executive. The legislature is trying to impose on international relationships in an improper way. Okay. No, because Congress has the power to implement treaties, and therefore the statute is binding on the president. No, because the Congress has the power to regulate commerce with foreign nations, and therefore the statute is binding. Yes, because Congress has no jurisdiction on matters outside the United States border. Ha. Yes, because president's subordinates are the exclusive official representatives of the United States. That's the one you want. Thank you for your super chat. Thank you for your tip. You just tipped $4.20. iThinXO. When you say tipped, did you go through the StreamYards link or Streamlabs link to donate? Is that why it says tipped? I'm just confused because I'm confused. It's early and you have to forgive me. When you donate your $4.20, did you donate it through the Stream Labs link? You probably did. That's probably why it says tipped. I'm confused. It's early. Let's move on. A citizen sued a police officer in federal court alleging the officer violated the Fourth Amendment rights. The citizen claimed the officer illegally entered her home, conducted an unlawful search. Streamlabs? Yeah, thanks. All right, great. Conducted an unlawful search and wrongfully seized her property. The case went to trial and the verdict was split. As to unlawful search and wrongful seizure of property claims, the verdict was in favor of the citizen. As to the illegal entry claim, a verdict was returned in favor of the police officer. Judgment was entered accordingly. Okay. Each side timely appealed. The citizen does not make a motion for judgment as a matter of law on a legal entry claim before the case was submitted to the jury, but on appeal she argues she could have won the illegal entry claim as a matter of law. Is the court likely to consider? No, it sounds like it's too late to me. I think so. That makes total sense. That makes total sense, and at a different time of day I might have gotten there. But we are where we are. But thank you for the chat again. And thank you for using the link because it is cheaper. It's better for me because YouTube takes 30% and they decidedly do not. I forget what the cut is actually on StreamYard Labs, but it uses PayPal, so I think it's like under 10%. So I get more of the money and it doesn't cost you anything differently, so I appreciate it. Pressing on. Okay. Is the Court of Appeals likely to consider the argument? Probably not, because they didn't bring the motion in. It's too late. Yes, because no reasonable jury could have rendered the verdict for the police officer in the illegal entry claim. Yes, because the appellate court has no authority to deprive a party a benefit of a jury verdict in his favor. What? No, because the appellate courts are not permitted to consider motions for judgment as a matter of law for the first time on appeal. Bing, 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 that'd be a winner. No, because federal statutory law denies jurisdiction in federal courts to entertain post-trial judgments for judgment as a matter of law. That doesn't sound right at all. I think the issue is that we're trying to bring this for the first time, and you can't do that. And that is the problem. You can't do it. You use it or you lose it, baby. 4 hours into defendant's assault trial, the lawyers gathered in the judge's chambers to discuss an evidentiary issue. While there, the judge received a phone call from his wife telling him his mother had suddenly died. Manifest necessity. Without asking the lawyers what they wanted to do, the judge brought the lawyers back in the courtroom, declared a mistrial, excused the jury, and rushed home. Manifest necessity. A new jury is impaneled the next day before the second judge. The defendant has objected to the second trial in double jeopardy. No. Will the second trial violate double jeopardy? No. No, because the first judge acted in good faith in declaring a mistrial. No, because the first judge did not produce the verdict. That's not the answer. Yes, because the second judge's evidentiary rulings might be inconsistent. That's not the answer. Yes, because there's no manifest necessity. Okay, so the question is there manifest necessity? That's what they're asking me now. And now they're saying there isn't. Good faith is not the right standard, though. So I think the answer is D, because it says acting in good faith. Good faith is not the right answer. The right answer is manifest necessity. Now, it says there is no manifest necessity, which I'm not sure is true, but it's the best answer. Yeah. There was no manifest necessity. Let's see if it defines manifest necessity. Hung jury or misconduct by the defendant? Okay. Acting in good faith is not the proper standard. That's right. And it wasn't for manifest necessity? Not so sure about that one, but okay. I mean, it's the best answer, though, so we reasoned our way through it. Plaza Hotel sued Plaza House Hotel for infringement of its trade name. Sounds promising. To establish likelihood of name confusion, plaintiff Plaza Hotel offers a series of memorandum in which it asks employees to prepare at the end of each day, listing instances during the day in which telephone callers, cab drivers, customers, and others had confused the name. Sounds like promising evidence to me. The memorandum should be excluded because they are more unfairly prejudicial and confusing than probative. Bullshit. Excluded because they're hearsay not within any exception. No, that's not the issue. Admitted because they're records of regularly conducted business activity. Admitted because their past recollections recorded. Past recollection deals primarily when the current witness doesn't remember, which isn't indicated here. I think the answer is C, but if it says I'm wrong, I'll understand. It is B. The memorandums are being offered for the truth of the matter, sir. The name confusion occurred. As such, they're hearsay. You can't offer the memorandums, but you can get the witnesses to testify about them. So this is like one of those things that like can drive you a little bit crazy. I think, because I think you could get them on the stand and ask them, but you can't offer the memorandum. Can you pull it? Can you call them to the stand and can you ask them the question? I think so, because you're not strictly speaking offering it for the truth of the matter asserted. I don't know. I'd have to think about it. Something about this seems wrong. Oh well. Pressing on. The memorandums are out of court statements. Yeah, it asks about the memorandums. And they're not kept in the ordinary course of business, though that's why the problem was. And I knew that was an issue. I just thought it was the best answer despite the issue. But yeah, like if they kept these records normally, then you're there. But they don't. These are like records they're kept specially, so they're not in the ordinary course of business. So, yeah, it makes sense. I'm still trying to figure out whether or not you could ask the employees directly on the stand or not. I honestly don't know right now. Moving on. A banker sued a previous business partner in federal court under diversity jurisdiction for breach of contract. The business partner showed that, one, the banker was exploring the possibility of litigation against the business partner. The banker knowingly destroyed materials that contained evidence that was highly relevant to the case. Well, adverse instructions are on your way, my friend. The banker also created financial reports relevant to the issue case that contained material deviations from the destroyed files. Consciousness of guilt and, forgery of records and other things too. As a sanction, the district court dismissed the case with prejudice. That's a harsh sanction, but yeah. And entered judgment for the business partner. The banker appealed. How should the appellate court rule with regards to sanction? Well, it's a pretty harsh sanction, but yeah, I think you're there. Overturn the sanction and remand the case for further proceeding because no federal rules prohibit destruction or creation of evidence. Overturn the sanction and remand the case for further proceeding because the banker did not violate a court order in destroying and fabricating evidence. Really? Affirm the sanction as long as the court finds the district court's choice of sanction was not abuse of discretion. Hold it lacks jurisdiction. Yes, C is the correct answer. It's a harsh sanction, so that there's abuse of discretion, but that's the relevant standard. Like, maybe we could have done something less extreme, but abuse of discretion. A defendant is being tried for murder of a woman who disappeared 10 years ago and has not been heard from since. Her body has never been found. The prosecutor presents a strong circumstantial evidence that she was murdered by a defendant. To help establish the fact of her death, the prosecution has requested the judge give the following instruction based on a recognized presumption in the jurisdiction. A person missing and not heard from in the last 7 years shall be presumed to be dead. Is the instruction proper? Sure. No, because the fact that someone has not been heard from in 7 years does not necessarily lead to the conclusion the person's dead. No, it doesn't. It's a presumption, not a necessary conclusion. No, because mandatory presumptions are not allowed in a criminal case on the element of charge. It's a presumption. I think it's okay. Yes, because it expresses a rational conclusion a jury should be required to accept. Required is probably the wrong answer. Yes, because defendant has a chance to rebut the presumption by offering evidence the woman is alive or has been heard from in the last 7 years. So the question is a presumption in a criminal case? Well, it shifts the burden of proof by creating the presumption. It's not official notice. It's a legal presumption. It's a legal presumption that goes to a core issue. It's a legal presumption that shifts the burden of proof. So I'm going to say B. They are not permitted in a criminal case. Thank God. Yeah, watching channels like yours while you're doing this is awesome. Not only are you learning, but so are we. Law should not be elusive. Exactly so, right? This is exactly so. It's like, not only am I learning, testing my learning, confirming my learning, correcting my learning, but also I'm able to teach it because I understand it. For the most part, like even when I get it wrong, I understand the answer, and so I can teach it. Right? It's like, oh yeah, that's right, and let me reframe it and reteach it. So it's every once in a while, like, of course, I've disagreed with the bar. I've disagreed with the bar at times, and told you about those. And also, I have not understood things once or twice and told you about that. So, like, I don't hide the ball, right? If I don't understand, I'll be like, I don't get it. Or if it's confused, or if I disagree, I explain the disagreement and explain why I disagree and the logic of my disagreement. But like, yeah, it's great because like, it's good for me because it tests my learning, reaffirms my learning, confirms my learning, and also I get to teach it all at the same time. Pretty kick-ass, isn't it? Thank you. I'm glad you like it. A nephew and niece inherited vacant land. The nephew soon discovered the land. Can I become judge one day? I could. In Texas, it is elected. I think I have to be a judge for 4 years before running, but yeah. And that was recently changed by the legislature, incidentally. I think it was changed like 1 year ago or something, so it's relatively a new change. But yeah, theoretically, I could be a judge one day. Of course, Biden could always nominate me today. That would be great. I'm available. A nephew and a niece inherited vacant land. The nephew soon discovered the land was subject to a mortgage held by a local bank, which required monthly payments for the next 10 years. Without telling the niece or seeking permission, the nephew paid the mortgage for 1 year. Nephew has demanded immediate payment from the niece for one half of the mortgage payments he had made. The niece refused. Well, yeah, no. If nephew sues the niece for contribution, who will likely prevail? The niece, because, yeah. The nephew, because of doctrine of exoneration. I don't know what that means in this context, so I'm going to assume it's wrong. The nephew, because without his payments, the bank could have foreclosed the mortgage and they could have lost the land. The niece, because any such payment is not due until a partition proceeding is held. The niece, because the nephew did not seek or obtain her consent before he made the payments. Hello, T in Tennessee. Glad to have you here as always. Thank you for your ha 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 emoji. It is cute and it entertains me. I appreciate it. Okay. A nephew and niece inherited the land. The nephew soon discovered the land was subject to mortgage, which required payment. Without telling niece or seeking permission, he paid mortgage. Okay, they own the land together. It's subject to mortgage. He's paying the mortgage. They're both responsible for the mortgage. So he can get half of it from her because they both own the land together. So that makes total logical sense. Okay. Now that I've properly read the question, let's give the answers again. Okay. If they sue for contribution, who will likely prevail? The nephew will. The nephew, because of doctrine of exoneration. The nephew, because without his payments, the bank could have foreclosed the mortgage and they could have lost the land. That's not the reason. The reason is because they both own the land together. So they're both responsible together. So the answer is A. So I have absolutely no idea what exoneration means, but it must mean exactly what I just said because it's the only possible answer. Let's see. No. B. But without his payments, the bank could have foreclosed and they could have lost the land. While neither is personally liable in the mortgage, failure to pay could foreclose the mortgage. Neither is personally liable? That's probably true. I mean, that is technically correct. Neither is liable because neither agreed to the mortgage. That's true. All the bank can do is take the land. That's fair. To avoid foreclosure, payment must be made to the bank as co-tenants. Each is responsible for the share. The Nathan paid more in his pro rata share and may recover the amount owed by Nisa in contribution. Okay, that's fine. That's fine. A woman brought a wrongful death action against a car driver who hit and killed her husband while her husband was crossing the street. In settlement negotiations, the driver told the woman that he was sorry for what happened, and he'd been too drunk to drive when he ran into the husband with the car. In settlement negotiations are the key words of those sentences, by the way. In settlement negotiations. The woman and the driver settled the wrongful death action for $1 million. Subsequently, the driver was charged with reckless homicide with the husband. At the driver's criminal trial, the prosecutor offered as evidence of guilt the driver's statement to the woman during the negotiations. Is the driver's statement to the woman admissible in the subsequent prosecution? No, because it's hearsay without exception. Hearsay is not the problem. No, because the statement made in civil negotiation settlement between private parties is not admissible to prove the validity of a claim in subsequent criminal prosecution. Promising. Yes, because the statement made in civil statement negotiation is admissible in a subsequent criminal prosecution. Also promising. Yes, because the probative value outweighs the risk. Okay, so the question is exactly whether or not it's admissible in a subsequent criminal prosecution. Is it available? I don't know. C seems like the better answer. If it's B, it won't surprise me. It's just a pure issue of the policy of how does the law define this issue. What's the policy considerations? Settlement negotiations are normally secret. The question is it secret enough when we're talking about a subsequent criminal prosecution? And I don't know, but I'm going to guess it is. Let's find out. It's either B or C. Dealer's choice. It is B. Damn it. The rules distinguish between settlement negotiations involving private parties and those in public office. Statements made in negotiations relating to a claim by a public office in the exercise of enforcement may be admissible in a subsequent criminal proceeding, while statements made by private parties are not. Well, that even makes things more confusing. There's a split on the issue as to whether or not it's a private party or a public party. Well, that just makes things even more interesting. Okay. A buyer contracted in writing with a shareholder who owned all of XYZ Corporation's outstanding stock to purchase all the stock at a specified price per share. Are you Elon Musk? If so, I have some thoughts relevant to your ongoing woes. At the time the contract was executed, the buyer's contracting officer said to the shareholder, "Of course, our commitment to buy is conditioned on our obtaining approval of the contract from our parent company." The shareholder replied, "Fine, no problem. Aha, an oral agreement outside the contract, even better." The shareholder is willing and ready to consummate the sale of stock to the buyer, but the latter refused to perform on the ground, which is true. The parent company has firmly refused to approve the contract. If the shareholder sues the buyer for breach of contract and seeks to exclude any evidence of the oral condition, the court will probably do which of the following? Okay, fun times. Admit the evidence as proof of a collateral agreement. Admit the evidence as proof of a condition to the existence of enforceable obligation, and therefore not within the scope of the parole evidence rule, possible. Exclude the evidence on the basis of finding the parties' written agreement was a complete integration of the contract. Exclude the evidence as contradicted in terms of the written agreement, whether or not it was a complete integration. See? Damn it. The exception for parole evidence rule for conditions precedent applies regardless of whether the final writing is integrated. Really? Seriously? Kit Kat donated €5. Well, thank you very much, Kit Kat. That's very, very kind of you. I appreciate it. I mean, I appreciate anything that anyone is able to give. If it's $1 and that's all you have, I mean, like, it's $1 that you're donating to me, and I appreciate it. So, like, if £5 is what you have, and that's, what you want to show support for, that's great, man. You're awesome. We love you, Kit Kat. Parole evidence rule bars extrinsic evidence of prior agreement where the prior agreement contracts terms. Exception parole evidence rule applies where extrinsic evidence offered to prove the written agreement is taken into effect only upon the appearance of a stated condition. Because the buyer-shareholder agreement will only take effect upon approval of the parent company, extrinsic evidence of the state understanding is notwithstanding. The fact that the thing that's blowing my mind a little bit is that the exception to parole evidence rule for conditions precedent applies regardless of whether it's fully or completely integrated. Okay. Let's go on. I'm sleeping and resting as much as I can, man. I'm sleeping and resting. I got a good night's sleep. Ish. These questions must be draining. There's 200 of them on the exam. Yeah. It's like, well, yeah. A teacher brought a successful lawsuit against a charter school in State A federal court. The judge found the charter school had violated federal employment laws and awarded money damages to the teacher in the amount of $182,000. The charter school appealed and lost. The federal rules of appellate procedure permit an appellate court to punish frivolous appeals by assessing extra costs. Under State A's law, there's automatic 15% penalty to an unsuccessful appeal of awarded money damages. Is the appellate court required to impose it? No. No, because state law conflicts with the federal, which prevails over an inconsistent state law, or no, because only the federal rules of appellate procedure apply. I think on the appeal issue, like, there are no state law considerations. So I think that the answer is D. Because Erie only applies at trial. So D, I think. Thank God. Got rid of one of them right. Thank you. Oh no, the exam is like, this is one part of the exam. So the exam has 3 parts. It has a multiple choice portion, it has an essay portion, and then it has what's called the MPT, where it gives you, a problem and asks you to like draft like a memo or something. It gives you a closed file with closed like cases and stuff. So this is one of 3 portions, but it is the most important portion to my mind because, like, well, the essay questions are mostly about spot the issue. That's the essay questions are mostly about spot the issue. Once you spot the issue, then just dump everything you know about the issue onto the page. All right, just dump everything you know. And so then the issue is learning the substantive law. And so that's what we're doing, right? We're learning all the substantive things so I can dump everything I know onto the page. So it's like, well, let's talk about, adverse possession. In order to do that, here's what you need to do. Need to do. It needs to be open, notorious, and hostile for the set number of years. And it has to be, continuous. And so forth and so on. And here's all the factors that play, and here's none, and blah, blah, blah. And, oh, we have an easement. We have different kinds of easement. Easement by necessity, easement by implication, easement by easement by implication, easement by necessity, easement by prescription is the other one. Let me tell you all about those things in detail because I know all the substantive rules that apply to that. Oh, good. It's a rule against perpetuities. Let me explain that to you with the substantive detail. Okay, has to vest, if at all, within 21 years of a life of being. Let's go do some wonderful analysis. Oh, joy, oh, joy, it's this problem where the person sold the guitar and let's go walk through everything, right? So, once you've spotted the issues, it becomes easier. So that's the essay, spot the issue and then dump everything you know about that issue onto the page. So, anyways, pressing on, I'd like to continue to learn things so I can dump things onto the page. I think the essay should have a logical structure, not just a mind dump. Well, it has the appearance of a logical structure, but it's mostly a mind dump. It has the appearance of a logical structure, but it's mostly a mind dump. I mean, you can't just do it in outline form. You can't just write it in outline form. You do have to compose it into, an essay, but it's really just an info dump. And the rest is window dressing. Why is it dark? That's the amount of light coming in the room at the moment. I haven't put on the key light in front of me. I'm good. We're sitting here in the dark together. It's fine. A seller entered into a written contract with a purchaser for sale Greenacre. The contract was dated June the 19th and called for a closing day on the following August 19th. There was no other provision in the contract concerning the closing date. The contract contained the following clause: subject to the purchasers obtaining a satisfactory mortgage at a current rate. On the date provided for closing, the purchaser advised the seller he was unable to close because his mortgage application was still being processed by a bank. The seller desired to declare the contract at an end and consult his attorney regarding the legal position. Which of the following are relevant in advising the seller of his legal position? Only the statute of frauds and whether time is of the essence. Only the parole evidence rule and specific performance. Only the parole evidence rule, the statute of frauds, and specific performance. The parole evidence rule, the statute of frauds, specific performance, and whether time is of the essence. How's the statute of frauds coming into this? And how's the parole evidence rule coming into this? What am I missing? The contract, okay. A seller entered a written contract with a purchaser to sell Greenacre. The contract was dated June the 19th and called for a closing date on August 19th. There's no other provision in the contract concerning the closing date. So I'm assuming the contract is otherwise complete, in identifying the land and the purchase price and other stuff. The contract contained the following clause: subject to the purchaser obtaining a satisfactory mortgage at a current rate. On the date provided for closing, the purchaser advised the seller he is unable to close because the mortgage application was still being processed. The seller desired to declare the contract at an end and consult his attorney regarding the legal position. Which of the following are the relevant issues? How is statute of frauds an issue here? Everything's in writing. I don't understand how statute of frauds is an issue. Parole evidence rule? What? How are we trying to bring in oral anything? I'm so confused. How is statute of frauds an issue here? I'm missing. Time is of the essence is the one that screams to me the most. I'm just having a trouble deciding how any of the other ones are relevant. Parole evidence rule, statute of frauds, and specific performance. How's the parole evidence rule getting into this thing? Statute of frauds, I'm not even sure how statute of frauds is getting into this thing. Specific performance, I understand. Time is of the essence, I understand. Parole evidence and statute of frauds, I'm having trouble with. I guess C? No, it would have to be D. Because time is of the essence is one of the factors, to be sure. So it's either A or D, right? It's either A or D. It's either the statute of frauds or but specific performance is a viable issue. So it's got to be D. I'm just not, I guess. All right. We reasoned our way into the answer. Let's press on. A writer from State A filed a jurisdictionally valid diverse action against an editor from State B in State A federal court. The writer sought $125,000 in damages regarding the contract dispute. The writer's lawsuit was involuntarily dismissed because the statute of A limitations for the writer's claim had run. In State A, involuntary dismissal is not considered adjudication on the merits for the purpose of claim preclusion. Fine. The writer timely filed the lawsuit in State B, which has a longer statute of limitations. In State B, involuntary dismissal is considered an adjudication on the merits for the purpose of claim preclusion. Then the editor filed a motion to dismiss. Should they grant the motion to dismiss? No. No, because the writer is not barred under State B's statute of limitations. No, because State A law does not treat dismissal on grounds as an adjudication on the merits for the purpose of claim preclusion. Sounds promising. Yes, because State B treats dismissals on the grounds of state law as adjudication. Yes, because federal law holds that involuntary dismissals operate as an adjudication on the merits. I don't think so. State A, the issue is not that it's not barred. The issue is that State A, it was dismissed without prejudice is basically the answer. And it is the answer. In 1975, the owner of both Blackacre and Whiteacre executed and delivered two separate deeds by which he conveyed the two tracts of lands as follows. Blackacre was conveyed to my neighbor and his heirs as long as it's used exclusively for residential purpose, but if it's ever used for other than residential purposes, to the American Red Cross. Okay. Whiteacre was conveyed to my girlfriend and her heirs as long as it's used exclusively for residential purposes, but if it's used for other than residential purposes prior to 1995, then to the Salvation Army. Okay. In 1980, the owner died, leaving a valid will, which he devised all of his real estate to his brother. The will had no residual clause. This is not a problem. Statute of frauds. The rule against perpetuities is not a problem because we're dealing with a will. Dealing with D's, not a will. The owner was survived by a brother and daughter, who was the owner heir. The common rule against perpetuity applies in the state. Doesn't matter. And the state also has a statute providing that all future estates and interests are alienable, decedable, and divisible in the same manner as possessor and stores estates and interests. Okay. In 1976, the interest of the Red Cross in Blackacre could best be described as, well, a residual contingent interest or something. Valid contingent remainder sounds promising. A void executory interest? No. A valid executory interest? No. A void contingent remainder? No. I think it's a valid contingent remainder. Is it B? It's not certain to follow. This is a void executory interest because it violates the rule against perpetuities. Really? So we're doing a rule against perpetuities in an executed deed. Does the rule against perpetuities apply outside of wills? Because this answer says it does. Rule against perpetuity applies to deeds? Does it? Really? Okay. Mark and Marif says it applies to deeds. Okay, well, okay then. Pressing on. It applies to trusts? Does it? Okay. A contingent remainder follows a life estate or a term of years after it ends naturally. Okay. A company owned a large tract of land that contained coal deposits that the company intended to mine. The company acquired mining equipment and began to plan its mining operations. Just as the company was about to begin mining, Congress enacted a statute that imposes a number of new environmental regulations and land reclamation requirements in all mining operations within the United States. The statute made the company's planned mining operations economically infeasible. As a result, the company sold tracts of land to a farmer. While the sale price allowed the company to recover its original investment in the land, it did not cover the additional cost of the mining equipment the company had purchased or the profits it expected to earn from the mining operations. It sounds very, very sad. Did I ever take the PE exam? No. I had a computer engineering degree. I can't take the PE exam, and if I can, that sounds horrifying. Anyways, pressing on. In an action filed against an appropriate federal official, the company claims the statute affected a taking of property for which it's affected just compensation. No. In an amount equal to the cost of mining equipment purchase and profits expected to earn. Was the following adjudication? Mining company is screwed. The company should prevail on its claims for the cost of the mining equipment and for its lost profits. The company should prevail on its claim for the cost of mining equipment, but not for lost profits. The company should prevail on lost profits, but not the cost of mining equipment. The company should go to hell. D. Nice. What's PE? Professional engineering exam. Professional engineer exam. Which I don't know anything about, except it has a reputation for being difficult. Hey, I have a computer engineering degree, and you almost certainly can. Well, you have a computer engineering, I have a computer science. In most cases, you could get a controls PE or a power PE, even a straight up electrical. With a computer science degree? I can get a PE degree? I can get a PE? Can I get a PE with a computer science degree? Let's find out. Let's see. Electrical and computer. Electrical and computer engineering, electronics, controls and communications, and power. I don't know what any of that means. Why would I? Because I'm a masochist. I'm a sadist. That's why. Principles of Practical Engineering Exam test for minimal level of competency in particular disciplines. Designed for engineers who gained 4 post-years experience in their chosen discipline. Well, that'll be difficult, because I don't think I've got that. The Principles of Practical Engineering test for custom competency. It's designed for engineers who have had. It's designed for, but does that preclude me from taking it? Let's see. Some sort of exam fee is paid. References, materials, scoring, and reporting, pass rates. Let's take a look at the examinee guide. Can I take it? Do I qualify is the question that we're trying to solve, right? Or am I going to watch the Necklace Cruise penalty phase? No, there's no point. Appropriate confirmation letter? No. 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 Non-disclosure agreements. How do you determine if you can qualify for the exam? Can I take the exam? This is the question that we're trying to decide at the moment. Examinee guide, exam schedule, prep materials, examinee guide. I'm having trouble on their website determining who can actually take the exam. What do you actually have to do? What credentials do you actually have to take? You do not need evaluation if your degree was accredited by the Engineering Accounting Commission, Grading Commission of ABET. Well, my degree was approved by ABET. To earn a license to practical engineering, candidates must meet requirement. I don't know. You have to take the EIT. I'm having trouble determining whether or not I qualify for this thing. Register for the exam in Texas. Which one am I taking, FE or PE? I don't even know. Let's see. Let's take PE. Let's take EE. Let's take PE in computer science, electrical and computer engineering, electrical and electronics. Let's do computer engineering. About the exam prep, about the exam. FE is generally your first step in the process. Designed for recent students who've been close to finishing the degree. The P exam attests your ability to practice. Designed for engineers who have at least 4 years experience. Designed for and you're not allowed to do this are two entirely different things. I don't know. I might. That's something to contemplate. I can do that. I can become a professional engineer. I can do that. I can do all the things. I'm Uncivil Law. I kick ass. I take names. It would be hilarious This is basically me planning to take the professional engineering exam, basically for fun and as a flex to no one in particular. This is a very strange reason to take the PE exam, but like, I'm doing it as a flex to somebody. Yeah. I'll look into it. A company hired an attorney to sue a former company manager for violating a covenant not to compete. The company's president told the attorney the manager had begun working for a competitor and gave the attorney a copy of the signed covenant. The attorney brought a federal diversity action against the manager and attached to the complaint a copy of the signed covenant. The attorney also moved for a preliminary injunction referring to the attached covenant and submitting a support affidavit from the president. At a hearing on the preliminary injunction motion, the manager denied ever having signed such a covenant and conclusively demonstrated the copy of the signed covenant attached to the company's motion was forged. The court's own initiative ordered the attorney to show cause while the attorney should not be sanctioned under Rule 11. Would sanctions against the attorney be proper? No, I think they've got a top opportunity to cure. I believe you can take the PE as well without meeting other quals for the PE. Yeah, like, I don't know, like, can I just take any PE exam for the hell of it? I mean, my chemistry sucks ass. It's by far and away my weakest academic subject. But if I wanted to, can I take the exam in chemistry? Can I take the PE exam? Even though I have no chemistry degree and I've never passed a chemistry course ever because it was my weakest subject and I failed it and I hate it. Can I still take the PE exam? How does this work? Can I become a PE in chemistry for the hell of it? It's like, what are the rules here exactly? This is a lawyer to me. What are the rules? What can I do? Not what am I supposed to do? Not what is it designed for? What is permissible? What is the law? What is the law? Can I do it? You know, well, this test is designed for chemists who have at least 4 years of industry experience and possibly, you know, understand chemistry. I'm like, yeah, that's not me. Can I take it? Yeah, we don't think that's a good idea. Yeah, but you're not answering my question of can I? No, because the court did not give the attorney notice in 21 days of withdrawal. Sounds promising. No, because the motion was supported by evidence that was likely to satisfy objectively reasonable attorney. Yes, because the attorney filed papers with the court that contained untrue assertions of fact. Yes, because the attorney should have violated the manager's signature before attaching the covenant to the complaint. Well, 21 days to cure, I believe. Yeah, even on the court's motion, I think you get 21 days to cure. Okay, yeah, so the safe harbor only applies when a party does. And so the answer is B. It was supported by evidence likely to satisfy an objectively reasonable attorney. Cool. Do the whole catch me if you can thing and become licensed by testing all the things. Just hold all the PEs. That sounds like a lot of effort. It's like holding all the bar admissions at once, which is easier now thanks to the UBE, but still expensive. Like the primary reason I can't apply to the bar and hold the bar in all the states is just money. Like, it's expensive. Every state wants money to apply for the bar. Every state wants money to maintain the bar. And also the continuing legal education requirements. Oh my God. If I was admitted in every single state and I had to do CLE for every single state, like, that's a lot. It's possible, but it's a lot. Like, you could do CLE that would apply to multiple different states, but still, that's a lot. So it's incredibly expensive. Yeah. So getting a bar admission in all the states is not really. I suppose I could get a bar admission and then like become inactive where I don't have to do CLE just for the flex, but no, it's still expensive. Just have a wall of all the states, of all the bar admissions, all certificates that say I'm an attorney. Are you an attorney? Yes. Where? Yes. No reciprocity for the bar. Reciprocity rules, even where you have reciprocity, not the way you're asking the question, because even with reciprocity, you still have to be admitted into every single state. If your question is, by being admitted into a state, can I practice in any other state? The answer is no. You have to be admitted in every state, in every jurisdiction individually, incidentally. So like not only every single state, but there's 94 federal courts, by the way, plus there are 13 different courts of appeal, plus the U.S. Supreme Court. So let's see how many different jurisdictions. Oh, and also, of course, there are the individual jurisdictions. I don't know what the rule in Puerto Rico is, whether or not they have their own bar exam. Honestly, God, don't know. I would imagine. So how many different bar admissions are there in the United States? Let's count. And let's assume that Puerto Rico and the other ones have it. All right. So that's 50 U.S. states plus D.C., so that's 51. Plus the 4 territories, so that's 55. Plus 94 federal courts, so that is 146. Plus 13 courts of appeal, so that's 159. Plus the U.S. Supreme Court, 160. There are 160, and if we count the patent bar as another one, that's 161. So there are 161 bars in the United States. Gotta catch them all Pokemon style. I don't know, man. I want to be the very best, like no one ever was. Catch him is my true quest, to find him is my cause. Pokemon. So yeah, this is just Pokemon, with me being the trainer Ash, just going around collecting the Pokemon of the 161 different bars, and paying God knows how much money just because I can. Now, if this YouTube channel really, really takes off and like becomes massively financially viable, then sure, I'll do it. Just because I'm a complete masochist and I don't mind the self-flagellation. I'll do it because as long as I have the money to do it, sure, I'll do the bar exam in every fucking jurisdiction just so I can be the guy who has a bar exam in every fucking jurisdiction. That sounds like fun because I'm a masochist and I have no compunction. So, sure, help this channel grow and help it, bring in like, I don't know, a significant amount of money, and sure, I'll just get bar admission in every jurisdiction. And then once I do that, we'll start talking about other countries, because that sounds like fun too. Maybe, I don't know what the rules are, but maybe if I get bar admission in literally all of them, maybe like I can get bar admission in the UK or Australia or something. I don't know. Or Canada. Ooh, that'd be fun. Well, I'm a lawyer fucking everywhere. All right. Bar exam sub goals. There you go. Yeah, that's right. I like this plan. I use the word like very loosely. Like every 100,000 subscriptions I get, I celebrate by taking a bar exam. There you go. Every 100,000 subscriptions I get, I celebrate by taking a bar exam somewhere. Fun times had by all. Fun times had by all. Oh, and then like I don't know what the law is for sure, but we do have treaties of free association with a couple other countries. Let's see, because there is I can't name them all, but there is can I name any of them? Micronesia. There you go. That's one of them. So here's a fun little factoid, right? Like if I want to go work in Micronesia, I can. I don't need a special license or special permit. Right? Like if I want to work in most countries of the world, I've got to ask their country for permission, because and like get a visa and shit, right? But Micronesia, despite the fact it is an independent country in every possible respect, we have a treaty, we have a compact of free association. So them and like there's like 3 other countries which I can't name off the top of my head, but there are like 4 countries where the United States, basically you as a U.S. citizen, if you want to, here's options you didn't know you had via Uncivil Law. You don't like the United States anymore and you would like to go work in a foreign country, but getting the permitting to work in that foreign country is really, really hard. Not a problem. I have 4 countries where you can go work today without any special permission, one of which is Micronesia. So then the question is, can I take the Micronesian bar exam, or how does that work with the compact of the free association? I don't know. But we could find out. A defendant entered a county museum at a time when it was open to the public, intending to steal a Picasso etching. Once inside, he took what he thought was an etching from an unlocked display case and concealed it under his coat. However, the etching was a photocopy of the original that had been loaned to another museum. A sign over the display case containing the photocopy said that similar photocopies were available free at the entrance. Defendant did not see the sign. Burglary in the jurisdiction is defined as entering a building unlawfully with intent to commit a crime. It's open to the public, so it's not burglary. Defendant is guilty of larceny. Right? The fact that other copies are available for free is irrelevant. He took this copy, and so it is larceny. And it is larceny. And it's a stupid larceny because he could have had any of the other copies for free. But he took this copy, so it's larceny. A farmer injured by a machine sued the machine's manufacturer on his own behalf and as representative of a class of individuals. After this bar exam is over, I should definitely look into whether or not I can take the bar exam in one of the compact of free association countries. Maybe I could go practice law in Micronesia. Sounds nice. I'm not sure how much Micronesian law there is, but, I guess we could find out. A farmer injured by a machine sued a machine's manufacturer on his own behalf and is representative of a class of individuals injured by the same model machine during the last 5 years. The farmer alleged that the machine was defectively designed and the manufacturer because the machine failed to shut off when the key was removed from the ignition. Therefore, the machine subjected its users to risk of bodily injury. The suit was brought in federal court and satisfied the requirements for diversity. The farmer sought compensatory damages both for himself and for members of the class. He timely filed a request for a jury trial on his own behalf and on behalf of the class. Historically, class actions are devices available exclusively in equity. True, but not so much now. The farmer requested the court certify the action to proceed as a class. In response, they moved to strike the jury demand. How is the farmer entitled to a jury trial? Well, if they have any claims that are based in law, yes. Yes, on both the issues of class certification, no. And on the underlying matters of the merits, no. The class certification is a pure issue of law. There's no jury. Yes, but only on the underlying issues of the merits. That sounds promising. Yes, but only on the issue of class certification. Absolutely not. No on either. On the underlying merits of the class of action. And that answer is B. Supreme Justice of Micronesia? Could be. There was that U.S. citizen who became king of an African country. It might have been queen because it might have been a woman. I forget. And they might have been elected king. I forget the exact details, but it definitely happened. There was definitely a U.S. citizen born in the United States who became king/queen of an African country to which they might have been elected as such, but it definitely happened. So stranger things have occurred. So I'm just saying there are options in your career path that you didn't even know existed. You too might be able to be appointed/elected king despite the fact that you were born of and are a citizen of the United States. Okay, pressing on. So Supreme Court Justice of Micronesia is not quite as inherently as absurd as you might have thought of when you proposed the idea. I'm just saying. The Federal Computer Abuse Act establishes the Federal Computer Abuse Commission, authorizes the Commission to issue licenses for possession of computers on terms that are consistent with the purposes of the Act and make unlicensed possession of computer a crime. Well, that's pretty harsh. The provisions of the Federal Computer Abuse Act are inseverable. Inseverable is a way of saying if one portion of the statute is invalid, the entire statute dies instantly in a heap of fire, which is not the standard rule. A user applied to the Federal Computer Abuse Commission for a license to possess a computer. The commission held and the user participated in a trial-type proceeding on the user's license application. They are very serious about the licenses for a computer over here. In that proceeding, it was demonstrated the user repeatedly and intentionally used computers to introduce secret destructive computer programs, computer viruses, into electronic banks without the consent of the owners. That is bad. As a result, the commission denied the user's application for a license. The license denial was based on the commission's rule authorized by the Computer Abuse Act that prohibited the issuances of licenses to persons who had engaged in such conduct. Sounds promising so far. Nevertheless, the user retained and continued his use of a computer. You mean that the law didn't stop him from doing something illegal? Oh no. He was subsequently convicted of a crime of unlicensed possession of a computer. What's the difference between larceny and burglary? Let me finish this and I'll get back to you. On appeal, he challenges the constitutionality of the licensing provision of the Federal Computer Abuse Act. Sounds okay to me, unfortunately. In the case, the reviewing court will probably hold that the act to be constitutional because the Constitution generally authorizes Congress to enact all laws that are necessary and proper to advance general welfare. That is the wrong answer. Constitutional because Congress may use the authority vested by the Commerce Clause, there you go, to regulate possession of computers, and the provisions of the Act do not violate any prohibitory provision of the Constitution. B sounds very, very good. Unconstitutional because Congress may not impose a criminal penalty on an action that's improper, merely because it's inconsistent with the agency rule. Yeah, lol, no. Unconstitutional because mere possession of computers is a wholly local matter that's beyond the regulatory authority of Congress. You guys know that one's wrong, right? So in this dark draconian hypothetical, this statute is nevertheless constitutional because Congress has so much power under the Interstate Commerce Clause, and that's the right answer. Okay, as to your question, what's the difference between larceny and burglary? Okay, larceny is just a term for theft. Larceny is when you take a thing. So I take with intent to permanently deprive, incidentally. So larceny is where I steal something from you with the intention of keeping it forever, right? So that's larceny. It's theft, basically. All right, so burglary is when I go into someone's house to commit a crime therein. The crime could be anything. Well, I have to unlawfully enter the house, right? So that's one step. So burglary is two things. I unlawfully enter the house for the purpose of committing some crime while I'm inside the house. It can be anything. So larceny could be the crime, like I'm intending to steal from the house. That's burglary, but it doesn't have to be. Like technically, if I'm intending to commit a murder, it's still burglary. It's also murder, by the way. But yeah, it's still like, yeah, there you go. And then of course there's robbery. Robbery is larceny with the person involved. So robbery is where I commit a larceny by taking the thing from the person or from their immediate possession or like in their presence, apparently. So robbery is larceny plus taking it from the person. Burglary is going into a person's house improperly and wanting to do bad things in there. Larceny is taking someone's stuff with intent to permanently deprive. I hope this answers your questions. A state law provides some funding for public schools on a per-student basis from general state revenues, which primarily come from state income and state sales tax. The law also provides that all their public monies used to support public schools in the state come from locally levied real estate taxes. This is a fairly typical structure for funding schools, so far so good. This results in a large disparity in per-student funding among the state's many public school districts because some districts have higher property values than other school districts. Yes, but wealth is not a suspect class. So you can discriminate on the basis of wealth, which we are doing. So that's fine. Public school students who claim to be disadvantaged by the school funding have challenged the law solely on the ground it violates the 14th Amendment's Equal Protection Clause. No. Which of the following best states the burden of persuasion in this action? Okay. The state must demonstrate the law is necessary to vindicate a compelling state interest. No. The state must demonstrate the law is rationally related to a legitimate state interest. No. The students must demonstrate the law is not rationally related to any legitimate state interest. There you go. The students must demonstrate the law is not substantially related to an important state interest. No. Rational basis is fine. Wealth is not a protected class. So the constitutionality of the law is presumed. So in order to defeat it, it is up to the students. It is their burden of proof to prove the statute falls for any possible legitimate reasons. So, basically just no. And that is the right answer. I'm happy to entertain you while you are auditing your spreadsheet. Good luck. A seller signs a valid contract with a buyer for the sale of a restaurant building. The contract provides that the closing would occur. Let me just check my messages real fast. No messages. Great. Carrying on. The contract provides that the closing would occur at the office of the seller's attorney 30 days after the day of the contract. 20 days later, the buyer asks the seller if closing could be postponed for 15 days beyond scheduling date. Okay. The seller authorized her attorney to email the buyer saying the closing date would be extended 15 days, but that time is now of the essence. Okay. The buyer emailed back that the change was reasonable and thanked them. All right, fine. We've got a modification in writing. Time is now of the essence with the 15-day extension. Okay, that's fine. That sounds fine. On the rescheduled closing date, the buyer was in a car accident on the way to the closing and was hospitalized for a month. That is unfortunate. When the buyer was released from the hospital, he told the seller and the attorney he was now ready to close. They responded the buyer had breached the contract and there would be no closing. Can the buyer still enforce the contract? Well, let's read the answers and see what we got. No, because it was the buyer who had requested the change of the closing date. No, because time was made of the essence as a requested closing date. Possible. Yes, because buyer's failure to appear at the rescheduled closing was justified. Yes, because the original contract was salient. So the issue here is that their failure, their breach, is a justified failure, right? So it's either B or C. So, like, is it B or is it C? Like, it's not your fault that you're in breach. But if time is of the essence in the contract, like, you know, you can't force the contract through. I think the answer is B. Like, it's not your fault, but still, like, the contract isn't going to go through. And in terms of remedies, like, we'll deal with that. But, like, performance on the contract, I think the answer is B. If it tells me it's C, though, I'm not going to be shocked. Let's find out. It is B, yeah. Yeah. So that's the problem, right? So, like, yeah, you're in breach. It's not your fault. So in terms of, like, looking to remedies, in terms of, like, possible remedies of this thing, like, if you had given them money as liquidated damages or something, like, so if you had given them some money and be like, oh, these are agreed upon liquidated damages, like, we might very well be able to get the money back because, like, it wasn't your fault. So, but yeah, okay, carrying on. You guys understood what I meant. Hopefully. A landscaper from State A sues a homeowner from State B in state court in State B. The landscaper is seeking $100,000 as compensation for tortious injuries caused by the homeowner's allegedly negligent act in State B. Great. The homeowner filed notice of removal from federal court in State B. The land filed a motion to remand. I see no particular problem with this being in federal court, so let's go forward. Should the court grant the motion to remand? No. You know, because the federal court may use supplemental jurisdiction to establish subject matter jurisdiction. No, you can't. You know, because the federal court has subject matter jurisdiction under diversity. There you go. Yes, because the homeowner is a citizen of State B and action was state spot. Yes, because notice of removal should have been filed in state court. That doesn't even begin to make sense. The answer is B. The court has subject matter jurisdiction. Is it C? There is a, like, exception here, isn't there? As a citizen of the state where the original action was brought, the homeowner's removal to federal court is improper. It's an exception to the removal thing. Because you're a citizen of the state, you can't remove it to federal court in that state. Because the whole point of removal is to, like, remove the home field advantage. But if you're already home, then, like, there's no point. A diversity case will only be removable if no defendant is a citizen of the state in which the action is brought. Yes, because it's the defendant who's asking for it. If they're a citizen of that state, then they should be happy in state court, because the whole point of the removal is to make things more balanced, but you're already balanced. So, like, they could have sued you in federal court, but if they're suing you in state court, like, you have no cause to complain. Makes total logical sense. I just kind of forgot it was a rule, which is one of the reasons that we study these things, so we hopefully learn them. A property owner hired by a person who does trees to cut down all the trees on the property and transport the trees to a lumber company. The owner agreed to pay the tree guy $10,000 when the work was complete. Tree guy said the work would take him 3 days. On the first day, the tree guy cut down all the trees. That evening, a fire caused by vandals completely destroyed the trees, making them unfit for use by the lumber company. What, if anything, must the owner pay to tree guy? Well, the contract was to cut down the trees and deliver them, which failed to occur. So we're going to probably pay him for like his reasonable loss personally. So we're probably not going to get the $10,000, but let's see what we got. Tree guy's expectation interest, $10,000 less any cost the tree guy avoided by not completing. Tree guy's restitution interest, which would be reasonable value of the services he rendered. There you go. Nothing because the contract was discharged by frustration and purpose. Nothing because he didn't complete the work. Well, he a little bit completed the work. So restitution interest, reasonable value of the services he rendered. There you go, right? So like, yeah, like makes sense. An author filed suit in federal court against several manufacturers of a product invoking diversity jurisdiction. The author alleged that he was exposed to the product that caused him the injury to his mouth. When the author filed suit, he did not know which manufacturer produced the product that caused him injury. This could be a problem, but let's read on. During discovery, the author made all required disclosures, including revealing name, address, and phone number of the persons likely to have discoverable information. Okay. After making these disclosures, the author learned from his dentist that an East Coast dental manufacturer created the product that caused the injury, but the author did not update his disclosures. That sounds like a problem. In response to the author's complaint, the East Coast manufacturer moved for summary judgment, claiming the author failed to prove that he had been exposed to East Coast products. Yeah, you can't kind of guess your way into it. You have to have something that makes you believe. You can't just be like, well, it's one of them. You know. The author opposed the motion for summary judgment, offered an affidavit from his dentist, affirming the dentist had used East Coast manufacturers' products on author. Okay, so the problem is his original complaint is defective. Can we fix it now in this way? I'm not sure. Let's read the answers, see what we got. Okay. No, because the author's opposition to the motion with the affidavit demonstrates a genuine issue of material fact. No, because the manufacturer did not provide any affirmative evidence to show the author's claim lacked evidentiary support. That's not the right answer. Yes, because the author failed to supplement his discovered disclosure and may not rely on the affidavit to create the existence of material fact. That sounds promising. Yes, because author's opposition to the motion with dentist affidavit was not enough to create a genuine issue of material fact. Yeah, the problem is you didn't supplement your disclosures, and you can't now rely on the affidavit to create an issue of material fact. That is not going to work. So C, I'm pretty sure. Yeah, that's the right answer. Bossy says, I feel like I know this, but if you're transferred to your law firm in another state, you need to bar in that state. Well, it depends on the nature of what you're doing, I suppose. Like, you need a license to practice law within and of that state. So like, if you're transferred by your law firm to a different state, but you're still doing law in the first state, then you don't need a license, because all your law you're practicing is still in the first state. Like, why they would do this, I don't know, but I'm just saying, like, for the purpose of our discussion, right? So if I'm licensed in, say, for example, Virginia, which I am, I can practice Virginia law no matter where I am, because it's Virginia law. So for reasons that pass understanding, I was working in Virginia and then I'm transferred to like Texas, but I'm still practicing Virginia law, then I can still practice Virginia law, because people still have complaints in Virginia, right? So someone could walk into my office in Texas and be like, hey, I have a claim in Virginia. Great. Because my practice of law is still in Virginia, right? The fact that they're in Texas talking to me is kind of neither here nor there, right? They're not asking me to do Texas, they're asking me to do Virginia. So whether I'm in Virginia or not is not a problem. So, but if they walk into my office and be like, I want you to file a lawsuit in Texas, now I have a problem. So I have to be admitted to the bar in any state in which I want to practice law within that state, if that makes sense, the way I phrased it. State X rules prohibit personal injury plaintiffs from alleging the damages amount in their complaints. Okay. A janitor from State X sues a mechanic from State A for negligence in State X court. In his complaint, the janitor alleges that, due to mechanic's negligence, he suffered multiple broken bones that required extensive surgeries and sustained brain damage. The janitor sought compensation for those injuries and pain and suffering and reimbursement of medical expenses. All right, so we don't have an explicit statement, but we have enough reason to believe it's over $75,000, so we can get there. Yeah. The parties participated in discovery for over a year, at which point the mechanic received timely answers to interrogatories that, for the first time, expressly indicated the janitor sought $1 million in damages. The mechanic promptly sought notice of removal to federal court, signing the interrogatory. The janitor moved to remand. Can you do that? Sure, yeah. Because the complaint on its face indicates damages over $75,000. So, this should be fine. Yes, because the mechanic failed to prove by preponderance of the evidence the amount in controversy exceeds $75,000. Yes, because the mechanic's removal to federal court occurred more than 1 year after the janitor filed the claim. How long do you have to remand? Well, good question. Let's read on. No, because janitor deliberately failed to disclose the amount of controversy. He didn't have a choice under the relevant state law. No, because the mechanic promptly removed the case after ascertaining the janitor was seeking $1 million. Okay, so D is possible. The thing is, the complaint on its face, although it doesn't state a number, alleges damages that seem to be in excess of $75,000. So it might be too late. Maybe he should have removed immediately. Brain damage, broken bones, blah, blah, blah. I'm going to say it's too late. Let's see if I'm right. I am too right. It's untimely. A couple who lived on the coast of State A purchased a vacation home in the mountains of State B. The couple purchased the home from a recent widow who permanently lives in State C. The widow has also used the home in State B as primarily a vacation property. How nice. However, without her husband, she is no longer able to maintain the property. The couple drove out to State C to the widow's home to sign the contract for sale of the property of State B. Okay. After documents were signed, the widow changed her mind and refused to give up the property. That sounds like a real problem. The couple brought a lawsuit against the widow to enforce their rights. Will State C's choice of law rules be applied to the suit? I think the answer is no, specifically because it's property. I think the answer is B, because it's specifically property, but let's see what we got. Yes, because State C is the woman's domicile. Yes, because State C is the contract where it was signed. Yeah, if it were a contract for anything else, but yeah. No, because the couple is domiciled in State A, so choice A laws will apply. No, because the property is located in State B, so choice B's will apply. Yeah, this is the problem. The contract being signed in State A or State C would normally be the right answer, but because it's land, I think the answer is D. And there's a special term for it, which I don't know, because it's something you would never remember. But I think the answer is D. And it is D. And it's not going to tell me the special term for it. There's a special term for it. But anyways, it doesn't matter. In a plaintiff's negligence action against a defendant arising out of a multiple car collision, a witness testified for the plaintiff that defendant went through a red light. On cross-examination, the defendant seeks to question the witness about a statement that the light was yellow, made in a deposition the witness gave in a separate action between man and woman. Sounds nice. The transcript of the deposition is self-authenticating. Yes, it is. A proper objection, the court should rule that the inquiry is admissible for impeachment, admissible for substantive, or admissible for both. It's admissible for both because it's an admission. Well, it's a witness, though. See, this is one of the things, as a lawyer, you don't care. you don't care because like it's admissible. Do you really care if it's admissible for impeachment only? Probably not. But the bar exam cares. So let's pretend we care for a minute. Is it admissible as substantive evidence? Well, it's a sworn statement in a different proceeding, so I think the answer is C. Can I play Street Fighter for a game? I don't have Street Fighter. I have Mortal Kombat, which I'm not very good at that either. A husband and wife walking on a country road were frightened by a bull running loose on the road. They climbed over a fence to get onto the adjacent property owned by a neighbor. You can do that. It's called private necessity. Right? You are doing something that's otherwise illegal, but you're doing it for a really good reason. In this case, the bull's chasing you, and we call that necessity. So, yeah. After climbing over the fence, the husband and wife damaged some of the plants which were near the fence. The fence was posted with a large sign, "No trespassing." Doesn't matter if it's posted or not. The entry is valid. That being the case, however, because this is a private necessity as opposed to public necessity, you will have to pay for any actual damages that occur. But let's read on. A neighbor saw the husband and wife and came towards them with his large watchdog on long leash. The dog rushed the wife. The neighbor had intended only to frighten the husband and wife, so their intent was assault. Fantastic. But the leash broke, and before neighbor could restrain the dog bit the wife. Transfer intent sounds fine. If neighbor asserts a claim against the wife and husband for damage to his plants, will he prevail? Yes, as I said, right? If the claim is trespass, no. There's privileged entry because of necessity. But it's a private necessity, so yes, actual damages. Yes, because husband and wife entered the land without permission. Yes, because the neighbor had posted this property with no trespassing. No, because they're confronted by an emergency situation. No, because they used excessive force. The answer is A. They entered the land without permission. The entry itself is permittable, but because, of the reasons I said, it's an incomplete privilege of private necessity. So they have to pay for the damages that they caused. If we're a public necessity, you don't have to pay for that, but it's a private necessity. So there you go. I never played Mortal Kombat. I mean, I would suck at it. I don't know. Yeah. An individual investor purchased stock through a stock company offering. When the price of the stock plummeted, the investor sued the company in state court in State A, claiming the company's offering materials had fraudulently induced him to purchase the stock and seeking $25,000 in damages. A university that purchased the company's stock through the same offering sued the company in federal court in State B, claiming the offering materials violated federal security law and seeking $1 million in damages. The individual investor's suit proceeded to trial. The state court ruled the investor's offering materials contained false information and awarded $25,000 in damages. Huzzah! The university immediately moved for partial summary judgment on its federal action against the company, arguing the state court judgment bound the federal court on the issue of whether the company was offering material containing false information. Neither state nor State B permits non-mutual issue preclusion. Should they grant it? Not a chance in the world. Different parties. It's a different party. Well, one of them is the same party. But it's a non-mutual issue preclusion, so probably no. No, because it does not permit non-mutual issue preclusion. No, because the federal court that sits in a state does not permit non-mutual issue preclusion. Yes, because federal law permits non-mutual federal issue preclusion. Yes, because the issue of whether materials contain false information was actually litigated and necessarily decided. Well, this is some like real topical shit. I'll say D and hope for the best. Is it A? The first case was decided in State Court A. Therefore, the second court, the federal court of State B, must use issue preclusion rules of State A, which decide the first K. State A does not permit non-mutual issue preclusion. Okay. When deciding which jurisdiction preclusion law applies, courts will apply preclusion law of the forum whose court rendered the judgment. If your earlier judgment was rendered by a state court, the state preclusion law applies under full faith and credit. If earlier judgment was rendered by a federal court that had federal question jurisdiction, federal preclusion law applies. If the earlier judgment was rendered by a federal court having diversity jurisdiction, federal pure preclusion law applies. But federal law calls for applying preclusion law of the state in which the federal court sits. I'm more confused, I think, than when I started the question. A landowner owned a vacant lot known as Rich Acre. The landowner entered into a written contract with the buyer, stating the landowner was to buy a house of stated specification on Rich Acre and then sell the house and lot to buyer. Okay. The contract provided for an inside date of April the 1st, 2007 and an outside date of May the 1st, 2007 for completion of the house and delivery of the deed. Neither party tendered performance on the date stated. On May the 3rd of 2007, buyer notified landowner in writing of buyer's election to cancel the contract because of landowner's failure to deliver. On May the 12th, the landowner notified buyer that some unanticipated construction difficulties had been encountered, but landowner was entitled to a reasonable time to complete. Probably. The notification was also included a promise landowner be ready to perform by May the 29th, as was setting that date as adjourning the closing date. Landowner obtained a certificate of occupancy and a procurement occupancy title and tendered performance on May the 29th. The buyer refused. Okay, so like the question is going to be basically, is this a reasonable time period? Probably. Which of the following most affects the outcome? Whether that's a reasonable time period, whether it's a reasonable, I don't know how else to say it. I'm sure they'll tell me. The landowner acted with due diligence in completing the house. That helps a lot. The buyer can prove actual hardship caused by delay. That would help a lot. The expressions inside date and outside date are construed to make time the essence. That would impact it quite a lot. The buyer makes a showing of good faith in effort to terminate the contract. Which would most impact the outcome? I mean, I guess the thing that would most impact the outcome would be C, that it's construed to make time of the essence. So, like, nothing else matters. I guess that's the thing that would matter the most, but I don't like this question at all. I don't like it. I don't like it even though I got it right, because it's like, it's a little bit subjective, to be quite honest, but fine. A college student was asleep in his bed in a college dormitory when his roommate, in a drunken fury, entered the room, intending to attack student with an ice pick where he slept. Fortunately, the phone rang and awoke the student. The roommate retreated quickly and threw the ice pick under his own bed in the same room. The next day, the student heard from the friend about roommate's murderous plans and later found the ice pick under the bed. Even though the college expelled the roommate, the student remained extremely upset and afraid to sleep. In a suit against assault, will the student prevail? No. He didn't see it, so there's no assault. Not in a civil case. No, because the roommate did not touch the subject. Wrong answer. No, because the student was not awake and was unaware. There you go. Not for assault. Try something else. A group of students at a state university law school wish to debate the future of affirmative action in that state at that law school. For this debate, they request the use of a meeting room in the law school that's available on a first-come, first-served basis for extracurricular student use. Speakers presenting all sides of the issues were scheduled to participate. The law school administration denied the use of the meeting room for this purpose solely because it believed that such a debate, even if balanced, would have a negative effect on the morale of the law school community and might cause friction amongst the students that would disrupt the institution's educational mission. This sounds like a thing a law school would actually do. Fuck them. If the law school's denial Is the law school's denial of its meeting room for this purpose constitutional? No. I'm assuming it's a state university, so it's a public school. And they are denying it specifically because, like, of the nature of the message. So that's viewpoint, basically, discrimination or subject matter discrimination. Either way, take your pick. No. So is it constitutional? No. No, because the law school cannot demonstrate its action was necessary to serve a compelling state interest. That would be the right answer. No, because the school cannot demonstrate its action was rationally related to a legitimate state interest. They could, but that's not the right answer. Yes, because the law school's only concern was the adverse effect of such discussion on the affirmative action of the immediate office and mission of the institution. No. Yes, because the law students do not have a right to use a state-owned law facility for a meeting that's not organized and sponsored. Yes, they do, under the way the school is creating it. So, yeah, you're going to need strict scrutiny, so no. When do I take the bar exam? Next Tuesday, a week from tomorrow. An employee, a citizen of State A, sued his employer, a corporation from State B, in federal district court in State B. The employee works in the corporation's factory located in State B. His complaint is seeking $125,000 in damages for the corporation's alleged violation of Fair Labor Standards Act, a federal law that requires higher pay to be paid for overtime work. The corporation filed an answer with a single counterclaim alleging the employee took $2,500 worth of corporation tools in violation of wrongful conversion. The employee then filed a motion to dismiss the counterclaim. Should the court grant the motion to dismiss? He's not arguing improper dismissal, so it's not relevant to the claim. So probably not. No, because the court has supplemental jurisdiction over the counterclaim. No, because the federal rules of civil procedure allow for permissive counterclaims. Yes, because the court does not have jurisdiction over the counterclaim. Yes, because the counterclaim does not arise out of the transaction or occurrence as the original claim. How many MBEs do I do a day? As many as I have energy for, basically, is the answer to that question. Just try to cram as much into my head as I have time for and energy for. I think D, but if they say B, we'll deal with it. It's C, it was none of those things. The court's permissive counterclaim, not based on the same transaction as the original, lacks independent subject matter jurisdiction. Okay, that makes sense. Supplemental jurisdiction does not apply because it does not arise out of the same nucleus of facts. That makes sense. That makes sense. The manufacturer entered into how long have we been streaming? 2 hours, 22 minutes? Yeah. How many people are watching the stream? 140? Okay. A manufacturer entered into a 5-year contract with distributor to supply the distributor with products to be distributed in State A. A manufacturer reserved the right to enter into an additional such contracts with other State A distributors. A manufacturer and a distributor would, on the basis of the agreement, invest in expansion of distribution centers in State A in order to handle distribution of the manufacturer's products to retailers in that state. At the time the manufacturer entered into the contract, it already firmly decided to withdraw from State A market in 2 years. Because the distributor heard rumors of such plans, its chief executive officer, before signing the contract, asked the representative whether such a plan was in place. The representative denied the existence of such a plan. Okay. 2 years into the contract, the manufacturer announced it no longer intended to sell products in State A and canceled its contract. The manufacturer did not supply products. Does the distributor have a viable claim of fraud? Yeah, because they were lied to. No, because distributors' exclusive remedies for breach of contract? Nope. No, because manufacturer did not mistake any material facts while entering into the contract? Yes, they did. Yes, because the manufacturer denied it had a withdrawal plan when the distributor asked about it at the time the contract was formed? There you go. Because manufacturers have the right to do business with other state distributors? Doesn't matter. Yeah, a material misrepresentation of fact in the creation of the contract. Sounds a lot like fraud in the inducement to me. Yes, no, maybe. Thank you. This is a practice test, yes. This is a practice test. Yeah. A defendant is charged with an offense under a statute that provides as follows. Any person who, while intoxicated, appears in any public place and manifests a drunken condition by whatever this is, I don't even know what that means, obstreperous or indecent conduct, is guilty of a misdemeanor. Okay. At trial, the evidence shows defendant was intoxicated when police officers burst into his house. Well, that's not a public place, so I don't care. And arrested him pursuant to a valid warrant. It was a cold night, and the officers hustled the defendant out of his house without giving him time to give his coat. The defendant became angry and whatever when the officers refused to let him go back and to retrieve the coat. The officers left him handcuffed outside the street, waited for a special car to arrive. The arrest warrant was later vacated. Can they be properly convicted? No. They're the one that forced him into public. So no. What state allows for people who haven't attended law school to sit for the bar exam? Virginia, California, and New York, I believe. Well, no, that's not strictly speaking true, because in New York you have to attend 1 year of law school. Virginia and California. No, because the defendant's claim of mistreatment is valid. No, because it requires proof of voluntary appearance in a public place. There you go. Salsa Mama says, this is so fabulous. I wish someone was doing this for the Florida bar. Well, let's find out if I am doing this for the Florida bar. Hold on. No, not formally. They haven't adopted the UBE yet. Oh well. Although the law is going to be very, very similar to Florida, but still, technically, yeah, fine. Moving on. But the law will be very, very similar. A man executed and delivered a promissory note and a mortgage securing the note to a mortgage company, which named as payee in the note and mortgage in the mortgage. Note contained a statement that indebtedness evidenced by the note was subject to terms of a contract between the market and the payee of the note, executed on the same day, and the note was secured by a mortgage of even date. The mortgage was promptly recorded. Subsequently, the mortgage company sold the man's note and mortgage to a bank and delivered to the bank a written assignment of the man's note and mortgage. The assignment was properly recorded. The mortgage company retained possession of both note and mortgage to act as a collateral agent. Okay. Later, being short of funds, the mortgage company sold the note and mortgage to a woman at a substantial discount. They sold it twice. That's fun. The mortgage company executed a written agreement, assignment of the note, and mortgage to the woman, delivered her the note, the mortgage, and the assignment. The woman paid value for the assignment without actual knowledge of prior assignment to the bank and promptly recorded the assignment. The principal of the note was not then due, and there had been no default in the payment of the principal. Okay. So, like, the woman's out of luck, right? Because the other assignment was properly recorded, so she doesn't win because she wasn't first, and she didn't get there first, and she didn't, okay. If the issue of the man's ownership of the man's known mortgage is subsequently raised in appropriate action by the bank to foreclose, the bank should hold the woman owes the known mortgage? No. The bank owns the note and mortgage. Oh my God. The bank gets them both. I mean, there's no argument to the contrary, is there? The bank owns both. Why wouldn't they own both? It's B, right? Yeah, it's B. I mean, yeah. They got both first in time. They recorded both first in time. This is like, why wouldn't it be? The owner of a truck leasing company asked one of its employees to deliver $1,000 to the dealership's main office. The following week, as a result of a dispute over whether the money had been delivered, the owner instructed the employee to come to the office and submit to a lie detector test. When the employee reported to the company's office for a test, it was not administered. Instead, without hearing the employee's story, the owner shouted at him, "You're a thief," and fired him. At the time, the owner accused the employee of stealing. The owner believed that to be true. The owner's shout was overheard by several other employees who were in another office that were separated from the owner's office by a thin partition. Defamation, maybe? We'll see. The next day, the employee accepted another job at a higher salary. Several weeks later, upon discovering the money had not been stolen, the owner offered to rehire the employee. In a suit for slander. Okay, so the question is, on what basis are we making the claim? That is one of the particular employees who has to. So is it negligent? Is the question we're trying. This is a private matter of private concern. So are we negligent for making the claim? Well, let's see. In suit for slander by the employee will prevail because the employee was fraudulently induced to go to the office for a lie detector test. That's not the reason. Prevail because the owner should have foreseen the statement would be overheard by other employees. Not prevail because the owner made the charge in good faith, believing it to be true, promising. Not prevail because the statement was made to the employee alone, intended for hearers only, but other people did hear it. So I think the issue is C. Like, the thing we're looking for is negligence. And good faith, believing it to be true, I mean, seems like the best answer. Okay. What is the correct answer? Prevail because the owner should have foreseen the statement would be overheard. Slander, spoken defamation, which must prove a whole bunch of other things. In this case, statement "you're a thief" would constitute slander per se. Agreed. Based on those facts, this is a defamatory statement concerning the plaintiff, which does not require proof of special damages. Yes. The only element issue is whether it was published. No, I think there's an issue of negligence in there. Okay, passing on. Two salesmen who live in different suburbs 20 miles apart were golfing acquaintances at the Interurban Golf Club. Both were traveling salesmen, one for a pharmaceutical company and the other for a widget manufacturer. Pharmaceutical salesman wrote the widget salesman by U.S. mail on Friday, October the 8th. I need a motorcycle for transportation to the country club and will buy your motorcycle for $1,200 upon your bringing it to my home address on or before noon of the 12th. This office is not subject to countermand. The widget salesman replied the following day by mail: I accept your offer and promise to deliver. The letter, although properly addressed, was misdirected by the Postal Service and was not received by the pharmaceutical salesman until the 10th. The pharmaceutical salesman had bought another bike from a different friend a few hours before. The friend saw the widget salesman at the country club on the 11th and said, I sold my bike to the pharmaceutical salesman yesterday. Would you consider selling me yours for $950? The widget salesman said, I'll let you know in a few days. On November 12th, the widget salesman took his bike to the salesman residence. He arrived at 11:15. The pharmaceutical salesman was asleep and did not answer the doorbell until 12:15. Salesman rejected the widget salesman's bike on the ground. He already bought someone else's bike. Okay. In lawsuits between the widget salesman against the pharmaceutical salesman for the contract, will the court properly decide regarding the widget salesman letter of October the 9th? Well, let's see. Which one was the October the 9th letter? I accept your offer and promise to deliver the bike. Meaningless. Because, well, upon your bringing it to my home address on or before noon the 12th. I would say they would accept it as a meaningful acceptance, but let's see what we got. Letter bound both parties to a unilateral contract as soon as the widget salesman mailed it. That's the wrong answer. Mailing of the letter by a widget salesman did not, of itself, prevent a subsequent effective revocation by a salesman of his offer. Okay. Letter both bound both parties to a bilateral contract, but only when received. That's the wrong answer. Regardless of whether the salesman offered her proposed a unilateral or bilateral contract, the letter was effective acceptance upon receipt, if not upon dispatch. D. Okay, I think I've turned into a pumpkin now. We have reached Uncivil Law turns into pumpkin time. We're 2 hours and 35 minutes into this, which is appropriate time to turn into a pumpkin. How did we do today? We hit 68.3% today. Not bad at all. Not bad at all. With 60 questions answered, we hit 68.3%. Not bad at all. Not bad at all. We're doing okay. Game time? I'm not even sure if I have energy for game time right now. I'm so tired right now. Well, I'm going to sign off for now. What's the passing percentage? I'd have to double check. I think it's about 70%. Thereabouts, something like that. I think about 70% of people that took it passed. Something like that. Out of 60, you got 55 correct? That's amazing. Well, I'm going to sign off for now. If you enjoyed the stream, I hope you would like, comment, subscribe, all the rest of it. I will see you later. Until later, my friends,